I am Bill Rochelle, ABI's editor-at-large. We're continuing with Eye on Bankruptcy, talking with Trish Redmond, partner at Stearns, Weaver, Miller in Miami. And one of Trish's claims to fame, among many, is that she was president of ABI in 2013 and 2014. Another notable fact about Trish is that she is a member of the esteemed American College of Bankruptcy. We thank you very much for taking time to come and visit with us. I think what we ought to do is perhaps tell our audience a little bit about what they missed by not coming to the ABI spring meeting in Washington. Now, you were on a panel about evidence. What a dry topic, I must say.
Yes, could be.
Or more so, perhaps unfamiliar to bankruptcy lawyers who can go through a whole career without ever having to make an evidence objection. But give us a thumbnail sketch of what you talked about in that program.
Well, we had a really interesting program. The program involved not just evidentiary objections, but also a model that was taken from the old game show called What's My Line? And our program was What's My Objection? And so we'd go through a scenario, question and answer, and then there'd be an objection. And each of the panel members would say the basis for the objection. 2 would be wrong, and 1 would be right. We then asked the audience to vote. The audience voted, and then we told the audience the right answer, and then, as a bonus, we told the audience how you could fix it. We had 2 trial lawyers, one from Boston, Jody Davis from Greenberg Traurig, and the other Jim Satilli from Jones Day in New York, and each one of them went through how they would ask the questions to make the questions correct so that they wouldn't be objectionable. We went through all kinds of foundational issues, hearsay, and other issues with respect to lay and expert witnesses.
Well, I guess that just goes to show you that ABI is not your grandfather's convention.
No, it's not. No, it's not.
Well, that's very creative.
It was great for bankruptcy lawyers. Yeah, a lot of bankruptcy lawyers end up trying their cases with direct testimony by affidavit.
Yep.
And so in the room, a lot of people commented that it was good to be refreshed to how to do this and think on your feet.
Very good. Well, listen, one of the things that you're up to these days is you're the chairperson of the 40 Under 40.
I am.
Whatever. What do you call it exactly?
40 Under 40. It's ABI's rolled out program, which we've rolled out a little before this conference. Lots of people are sending in their nominations. Nominations go through July 31st of this year, and at the Winter Leadership Conference, we're going to announce the 40 Under 40. The program is one that's designed to recognize people who are the rock stars of the younger generation. It's designed to identify future leadership, people who will be significant in our profession, and to make sure that we keep them engaged in this practice area so that we have, again, superstars as we go on.
So what can people in the audience do to participate in that program?
Very easy.
What's that?
You go on the ABI website, and there's a place to go to 40 Under 40.
Yep.
You send in someone's name, their name and their contact information. That's it. ABI then contacts that person for more extensive information, and that person sends in their information. I think we've had about 175 names submitted so far.
Wow. You just started.
And we just started.
Oh wow, that's pretty exciting. Well, listen, let's talk about Florida for a minute, because you're stationed in Miami.
I am.
And Florida has the distinction whenever there's a problem in the economy or whenever there's a fraud, Florida is at the cutting edge in the bankruptcy sphere. So how are things going in Florida these days? Busy down there these days or not?
Florida is the scamology capital of the world. And so, yes, we're on the cutting edge of fraud cases, not necessarily on economically based cases. But Florida reorganization and restructuring practice is very slow at this point. Most people are looking to non-bankruptcy alternatives.
Oh, really? How
Yeah.
come?
Because there's more economical, more efficient, and more certain in terms of outcomes.
Well, what are alternatives that folks are employing in Florida, and why?
Florida has a very well-developed assignment for the benefit of creditors statute. People are using that statute to liquidate businesses or for equity to make an attempt to buy back their business from
Oh, really?
creditors through a vehicle of an assignment. People are also using receiverships in the healthcare area and other areas to be able to liquidate businesses or to conduct a sale, again, without all of the expense that's involved in a Chapter 11 proceeding.
Well, it sounds to me like you're either ahead of or responding to some of the criticisms in the ABI Commission report on Chapter 11.
Yes, indeed. Yes, indeed. I think that what's really that the ABI Commission report identified certain flaws in the Chapter 11 process that caused the people who would be the users of Chapter 11 not to choose it. And Florida is one of those jurisdictions that is in large part not choosing Chapter 11 for the reasons the ABI identified.
Oh, now, how is it that, or why is it that ABC's assignments for the benefit of creditors and receiverships can work? Is it, well, I'm sorry,
go
go ahead.
ahead.
No, I was just going to say, is it local experience? Is it better designed local law? What is it?
I think that the cost of the proceeding, which is always a factor in today's world, is substantially less, and the outcome more certain. For example, for a small business.
Yeah, well, let's use that example. Owner of a small, medium-sized business walks into your office, says, "Listen, I can't pay my bills. I think I need to file reorganization." What's the conversation?
Okay, so the conversation is, let's look at what Chapter 11 can do for you. You go into Chapter 11, you have a creditors committee appointed, so you're already paying 2 sets of professional fees, so it's expensive there. You get to the plan stage, and if you're unsecured creditors or a deficiency claim controlled by a secured creditor happens to control that class, it's going to trigger the absolute priority rule, and you can't tell that client that at the end of the day, their goal to fix their business and to have it come out so that they have a business that they can make profitable again, you can't assure them that that's going to be the outcome. For example, if you contrast that to an assignment for benefit of creditors, where you go in and ASM takes control of an operating business, you make an offer to buy the business. And the market's going to control. If there's anybody else out there, if creditors object, it may cost more money to do that. But the process is going to be more certain. Now, is the assignment statute as developed as bankruptcy? Not even close. But do people take the chance because of the cost factor and at least the certainty of the outcome? Yes, they do.
Interesting. And so what if somebody with a small business files a Chapter 11 and it fails? What do you tell them about that eventuality?
Well, a couple things. Number one, Chapter 7 trustee is going to own the privilege, so anything you tell me is going to be discoverable. Number two, typical things Chapter 7 trustee.
Can you say that again? What did you just say?
Chapter 7 trustee is going to own the privilege, so anything that you tell me is going to be discoverable.
Oh, Lord of mercy, like how you company paid for your girlfriend's car?
That's right. That's
oh,
right.
Oh, Lord of mercy.
That's right. So you should have never told me that. And then the Chapter 7 trustees are likely to bring claims if there's a director and officer liability policy, if there's a malpractice policy, bring these kinds of litigation claims because that's where they typically get recoveries for unsecured creditors. So all that litigation happens in a Chapter 7, and it turns out to be something that's very painful, time-consuming, and a use of a lot of resources for that particular company.
Well, good grief, it sounds like we have killed the goose that laid the golden egg in bankruptcy by making it too lucrative for the professionals sometimes. Well, listen, let me ask you about this. Bankruptcy is essentially, in the U.S. now, an adversarial litigated process. Do you think it would be feasible either with consumer bankruptcies or business bankruptcies to have it more like an administrative process where there's less fighting among lawyers?
You know, Bill, you'll remember back to before 1978. The Brookings Institute recommended that Chapter 13 be an administrative process, and the code did not adopt that model, but in reality, Chapter 13 in many districts turned out to be primarily an administrative process, except for when things have to be heard by a court. All of the processing of the case, the review of the case, the recommendation of confirmation, all is administrative between a Chapter 13 standing trustee and the debtor. And that seems to have worked, and it's kind of just fallen into that pattern rather than having the pattern directed by the statute.
That's interesting.
So,
well, you know, I guess that explains something that I've heard from judges, which I frankly couldn't believe. A judge who's got a consumer docket would say, well, on Thursdays every 2 weeks, my morning calendar is 600 cases.
right.
And I'd
Right.
say that's impossible.
Right.
That's
Right.
You can't do that.
Right.
But I guess that's the explanation.
Well, you know, in my district, here's what happens. Chapter 13 trustee goes through the docket, calls all the cases. They have a recommendation that they say on the record. They say, for example, we recommend confirmation. And when they recommend confirmation, the debtor's lawyer stands up and says, agree. And that case never goes to the judge. That case goes for a confirmation order is submitted by the Chapter 13 trustee to the judge. So hundreds of cases in your example are decided that way. There are some people that stand up and say, judge. And when they say judge, that means their case gets put over to a calendar later that day.
This is all semaphore, huh?
Right.
Just little key.
Right. And there's a whole
code
different
words, huh?
language. Exactly. You say judge, and you get put over to the judge. And so there's maybe 10 to 15, maybe 20 cases that the judge hears in the afternoon quickly. And so that's how efficient, and that's how the cases work. But that's why the big part of this, you could say, depending on the jurisdiction, 70 to 95%
Yep.
of the cases are handled administratively.
No, well, that's good. It's expensive enough anyway for Chapter
Right,
13.
right.
This makes
Right.
it better. Well, what about business reorganization, Chapter 11? Do you think it would be feasible, perhaps, to tweak the statute so we could make it less litigious, quicker, cheaper?
You know, I think the ABI's commission's recommendation, especially for smaller, medium-sized enterprises, really deal with those things, and their recommendations, if they were ever adopted, could make a difference. And in the meantime, what we're doing in Florida is we're investigating a concept called collaborative law. And collaborative law has been around forever in family law. For example, a husband and wife that are going through a divorce can choose a collaborative approach and a track in their litigation. And so they don't litigate, and they work with counselors, psychologists, other kinds of facilitators and mediators to get to a resolution of their issues. What we're working on in Florida is a business law alternative for bankruptcy, where you would file a case. There would be a team in a law firm that would be the collaborative team. And those lawyers would be handling the case in the first instance if you elected to go on the collaborative track. There'd be a facilitator, like a mediator, a financial advisor appointed to the case. Those people would work with the parties to try to reach, it would kind of be like planned mediation, to reach a resolution of the issues in the case. And if they were successful, it would never go back to the litigators. And so the model is just in its early conceptual stages, but we're trying to get there. The idea, of course, is to be cheaper, more available, accessible, with more certain outcomes.
Well, that's
and we think that
interesting.
would be more attractive to
So
people.
you could do that, maybe needing only a local rule at worst, but
right.
well, that's fascinating. Well, you know, Trish, here we are sitting in Washington, D.C., And this is not the first time today, nor in these videos, where we have heard people complain, is that the right word, or criticize the current bankruptcy process. And these, by the way, are people who make their livings in the current bankruptcy process. But nonetheless, they're critical of the system we have right now and believe there should be reform. So maybe if we're lucky, if there's a God in heaven, we're sitting here in Washington, D.C., so that maybe some vibrations will emanate from here across the street to the House of Representatives, the Senate, and the President. And maybe they'll get the idea to pay some close attention to the ABI Commission report on
your
reform.
lips to God's ears.
Well, let's
or
hope.
to Congress's ears.
Well, better that. God will probably listen. I'm not sure about Congress. Trish, thank you very much for your time. Be well.
Yeah, you
Enjoy
too.
life, and I'll see you again soon.
Sounds good.